It truly is an honor to have the opportunity to introduce our guest lecturer this evening. As many of you will know, Justice Lasry, who was appointed to the Supreme Court last year, has, prior to going to the bench, enjoyed an extraordinary 35-year career as a barrister, including as prosecutor, criminal defense counsel, Queen's Counsel, and has earned worldwide recognition and respect for his defense of what he has termed elsewhere unpopular causes. A wonderful phrase, focusing in particular on his defense of suspected terrorists and persons facing the death penalty, the hard cases of human rights law. Justice Lasry, a former chairman of the Victorian Criminal Bar Association, past member of the Council for the International Criminal Bar for counsel practicing before the International Criminal Court, has worked on the defense of quite a number of such unpopular cases, including the Van Nguyen case, the Jack Thomas case, Murin Sukumaran and Michael Chan, and for David Hicks, at whose trial at Guantanamo-based Naval Bay, Cuba, he was independent observer for the Law Council of Australia between 2004 and 2007. In a lecture that Justice Lasry delivered for the 2006 Law Week oration at this law school, he quoted from Martin Luther King's 1963 book entitled Strength to Love. And I want to share with you tonight the passage that Justice Lasry chose to invoke that evening. He said, "The ultimate measure of a man is not where he stands in moments of comfort and convenience, but where he stands at times of challenge and controversy." This is clearly a standard that Justice Lasry not only embraces, but one by which he lives. Chancellor, distinguished guests, ladies and gentlemen, please join me in welcoming to the podium the Honorable Justice Lex Lasry.
Chancellor, Dean of the Faculty of Law, distinguished guests, ladies and gentlemen, thank you very much for that introduction. And can I say that which is obvious, that it's a pleasure to be back in this law school, and it's a particular privilege to have been invited to deliver this lecture tonight. Can I just say, by way of clarification, I only went to Guantanamo Bay twice. I didn't spend the whole 3 years there between... Human rights as a cause and as a calling for lawyers has, I think, developed dramatically since the Second World War. The end of that war also increased the internationalisation of criminal law through the trials at Nuremberg and Tokyo, and created a legacy which has found modern development with the International Criminal Court, which is not to say by any means that nobody cared about such things before then. Magna Carta was created in the year 1215, and the rights of habeas corpus, which effectively began with that document, remain an important basis of human rights law, particularly recently in the United States as challenges were made to the military commission regime. However, because, like the Universal Declaration of Human Rights, the State of Israel and Prince Charles, I turned 60 this year, and for the purpose of this speech, I've begun to reflect, to some extent, on some individuals, both locally and internationally, who I think have had an impact on human rights and their protection, in some cases because these people were doing no more than their job, a job that many of them were paid to do. And by and large, the people I have in mind are the unsung heroes, most of the time, of human rights defence. They are the criminal defence lawyers. Criminal defence lawyers are often maligned. However, these lawyers are often better described by people looking on as the individuals who stand between the subject charged with crime and the state. And in my opinion, the role of these lawyers has always been and remains a vital role. So therefore tonight I'm going to talk about some of them and the contribution they've made to the preservation of human rights, and for most of us, they're human rights that we take for granted and which some people think should be compromised in the cause of compromising the efficiency of the criminal justice system. As I've said, and as I've often said in the past, by virtue of the nature of their role, criminal defence lawyers are human rights lawyers. They may not see themselves in that role, but of course the protection of basic rights is inherent to the defence of individuals charged with criminal offences. And here it starts in a police station, when an individual sought to be interviewed by police as a suspect rings his or her solicitor and is advised of the right to silence. Later, human rights which are put into effect in the course of defending those charged with committing criminal offences include the right to require the prosecution to prove the charge beyond reasonable doubt, the right to equal treatment before the law, the right to silence, the presumption of innocence, the right to an adequate defence, the right to liberty, both in the context of imprisonment of an individual after conviction and in the context of detention of individuals prior or during criminal trials, and in other countries, fortunately not here, but in circumstances where capital punishment is still a penalty imposed on those or some of those convicted of criminal offences, the right to life, the right not to be subjected to torture or to cruel, inhuman or degrading treatment or punishment. And of course in Victoria at least we now have a Charter of Human Rights where many of those rights, if not all of them, are set out in legislative form. Although criminal defence lawyers are usually simply performing their job, they are fighting for the recognition and enforcement of human rights of their clients. And in some cases they have a significant impact on human rights issues generally and on public awareness. There'll be cases where fighting for an individual's right means that the defence lawyer finds him or herself advocating for a cause, which for some reason has a particular significance that reaches well beyond the individual accused. In this way, particular cases or particular lawyers can come to stand for particular social issues, and in such cases the criminal defence lawyer can have a significant impact on the human rights consciousness, and as a direct consequence of simply performing his or her role within the criminal justice system. Perhaps the most immediate example that comes to my mind, because I have a particular interest in it, is in death penalty cases, and we don't have to go out of this state to cite a few examples. In our own country and in our own state, a case that became iconic in this respect was the case of Ronald Ryan, the last person to be executed in Victoria in February 1967. Ryan was represented at his trial in 1966 and in later appeals by Phil Opus QC. While initially a firm believer in capital punishment, Opus's belief in Ryan's innocence and his perception of the political motivations for his client's execution changed his views completely about the death penalty. Every other individual on death row in Victoria in the preceding 16 years had had their death sentences commuted to life imprisonment. Liberal Premier Henry Bolte, however, successfully campaigned for Ryan's execution. In 1997, Opus personally published a book titled Throw Away My Wig, an autobiography of a long journey with a few signposts. The book begins under the heading A Cause for Reflection, with a description of the 3rd of February 1967, the day Ronald Ryan was executed. Quote, "I was no longer visualising the scene. I'd already done that too often. 2 nights ago in my hotel room in Bangkok," he was on his way home from the Privy Council at that stage, "the night that I was sure the hanging would be carried out, I could see it all happening. I could picture the crowded confines of the condemned cell. The state was about to commit judicial murder. Without the court judgment following the jury verdict of guilty, what was about to happen would be premeditated murder. This murder was long planned. The hangman and his assistant, appointed by the sheriff to carry out his gruesome task, had already carried out tests with carefully weighed dummies matching Ryan's body weight. It was important that he be hanged neither too much nor too little. If the rope were to be too long and the drop too severe, the head might be severed and roll under the Hessian curtain after bouncing on the floor. On the other hand, if the rope were too short or the knot placed wrongly, he might strangle and take a long time to die, to the embarrassment of the official witnesses. He must be killed scientifically by breaking his neck, quickly and painlessly. painlessly, it will of course be painless to the hangman and his assistant," unquote. After that case was over, Apos committed himself actively in the campaign to abolish capital punishment. And when the death penalty was abolished in Victoria in 1974, he continued to express his outrage at the continuing use of capital punishment overseas. In the time leading to the execution of Van Nguyen in Singapore in 2005, Phil Apos became a considerable support for me. He had become iconic as a death penalty lawyer, yet he did only one case. Whilst the defence team in the case of the Queen against Ryan and Walker also included the great Jack Lazarus for Walker and that great South Melbourne and Swans identity Brian Burke as Phil Apos's junior, it was Phil Apos who led the moral charge against the death penalty. It is part of his great legacy, and he would also claim a role in Geelong's 2007 premiership, that we can honour him and the stand he took all those years ago by being steadfast now in this dreadful and unjust penalty in our region. After an outstanding career in many facets of the law, Phil Apos passed away in Melbourne on the 25th of August this year. Justice of Appeal Frank Vincent, a very senior member of the Supreme Court of Victoria and a member of the Court of Appeal, was a barrister for 24 years before he was appointed to the bench. In those early days when Victoria had a mandatory death penalty, yes, mandatory, on conviction for murder, the judge had no choice but to pronounce the death penalty, Vincent appeared in a number of murder trials. Recently, in a speech marking the reopening of the Fourth Supreme Court in Victoria, he gave the following recollection, quote, "Counsel appearing in those trials were forbidden to refer to the death penalty. Of course, and particularly in cases where there was concern that it might be imposed, it was almost irresistible not to make some comment obliquely alluding to it. When this was done, judges would generally let the breach pass without anything being said. In that trial, however, my reference could hardly be described as a passing allusion. I concluded my final address with the statement that," quote, subquote if you like, "in one sense it can be said not to matter whether this trial ends with the clang of the jail gate or the snap of the gallows rope. Each is a terrible sound, and I pray to God that it will not be in the moment of silence that follows that sound that you discover the meaning of reasonable doubt," unquote. There were great pressures on these young lawyers at the time. Every tactical decision, and every defence lawyer understands the misgivings about tactical decisions, every tactical decision they made in the running of murder trials carries the "what if I am wrong?" question mark, and the possibility, the real possibility, that wrong forensic judgments could lead a client to being hanged. Most death sentences were commuted by the Executive Council, but it was not guaranteed, and of course it was in the hands of politicians. More recently, and since the abolition of the death penalty in Victoria and throughout Australia, iconic cases in the eyes of the Australian public have involved Australians charged with offences in foreign countries, where the death penalty might be imposed or already has been imposed. In the 1980s, Australians were introduced to the idea of Australians being executed in foreign countries by the case of Kevin Barlow and Brian Jeffrey Chambers, who were executed in Malaysia in 1986 after being arrested in 1983 with what by today's standards is a very small amount of heroin, about 140 grams. Those of you who remember the case might recall that Melbourne criminal lawyer Frank Galbally joined Malaysian lawyer Kapil Singh in the defence of Barlow. As Galbally describes, he first became involved in Barlow's case because it was his firm opinion, on the basis of all the evidence, that Barlow's right to a fair trial had not been protected and that he had therefore been wrongly convicted. Galbally says in a book dealing with the issue, quote, "I was not interested in the least whether Barlow was innocent. I was concerned with the fundamental principle of any civilised society which affirms that everyone is entitled to a fair trial and that no person should be denied justice. That is all the more important when the consequences of conviction are execution. I believe that Kevin Barlow did not receive a fair trial, and it was for this reason, regardless of any considerations of guilt and apart from any personal sentiment, that I felt so frustrated and aggrieved by his execution. In the end, Prime Minister of the day, Bob Hawke, described the execution by hanging of Barlow and Chambers as barbaric, a remark that had some significant effect on the relationship between the Australian and Malaysian government for some time afterwards. But it's funny how images stay with you, and I remember the image of the time shown on the news of the bodies of Barlow and Chambers on the back of a prison truck. All that was visible was their feet. 2 dead bodies executed by the state. In my own case, representing unwitting between 2002 and 2005, in working on the case of the 3 Australians who are currently facing the death penalty in Bali, I also found that in such cases advocating on behalf of a client to protect one of their human rights will often necessarily involve taking a stand on the death penalty more generally. In those cases, the criminal defence lawyers involved have each begun their role by exploring the ways in which individuals can be defended. Challenging the appropriateness of the death penalty as a criminal sanction inevitably played a big part in the defence of these cases, and the criminal process through which guilt was determined became, in a sense, a smaller part of the overall process of defending the client. In the Van Nguyen case in particular, and I regularly cite the example, I have a number of lasting memories, but the lasting and the most significant memory to the rule of law and its lack of application in that case was the response we received to the 70 or 80 pages of clemency petition we submitted to the President of Singapore after an enormous amount of effort, which was really the plea in mitigation that we would have made to a court. Took weeks to prepare, contained a significant amount of material in relation to constitutional issues, personal issues affecting our client, and so on. Time passed after its submission until our client's mother received a letter which was all of about 4 lines and said, in effect, the application for clemency is rejected, please make funeral arrangements. When one criticises that kind of process as being a violation of the rule of law, it's not hard to understand the logic. Here in Australia there is, of course, a band of lawyers, me once included, he said slightly nostalgically, who carry the responsibility for the defence of the 3 members of the Bali 9 who are on death row in Indonesia. This is very difficult work. It is often done at long distance. It requires talent not just for the law, but in foreign law, sometimes foreign language, diplomacy and the nuances of politics in this country and in the foreign country concerned. And unlike a lot of lawyers, there is no comfort that at least the effort that's being put in is, as some compensation, earning an income. Because in the case of the present team of lawyers, John Champion, Senior Counsel, my long-standing colleague and he's not here, I don't think, so I can say protégé, Julian McMahon and others, there is no fee. This is work that these people are doing, and it bears to keep it in mind as you see the case developing, because these lawyers believe in the principles which they are enunciating and endeavouring to enforce. In the United States, there are numerous lawyers who defend in death penalty cases day in, day out. In particular, because this particular example is a part of a project of a Melbourne lawyer, Richard Burke, is the Justice Centre in Louisiana. This centre was established in 1993 and intended to rectify some of the greater excesses of the death penalty in the southern states of the United States. The lawyers engaged in the centre are involved in a large number of death penalty cases, particularly at trial. What they noticed when the particular leaders of the centre got more involved was that the standard of defence advocacy in some of these cases was poor. Clive Stafford Smith, an English lawyer who was centrally involved in either establishing or invigorating this centre, told me on one occasion about one of his early death penalty cases which he'd come to after trial. One of the significant things about the trial was that counsel for the accused had slept through most of the trial. Ruefully, he said, I only need to stay awake to do a better job. The centre has worked actively to engage with victims of capital crimes, usually the family, of course, of a person who's been murdered. Some of those victims have been willing to lobby and speak publicly against the death penalty despite the loss they have suffered. The Centre has also concentrated on racial bias in the laying of charges, the selection of juries and the passing of sentences. This is very important work, flowing from the work done on a day-to-day basis on the cases they handle is the development of some kind of social policy which reduces injustice, changes opinions and extinguishes or diminishes long-held prejudices. This is where the work of lawyers who are primarily criminal defence advocates, but who understand the effect of their work is so important. And they adhere, of course, to one particular principle, which is best summarised by AIDS journalist Mark Baker, with whom I spent quite a bit of time in Singapore. State killing has no place in the modern world. Other examples of cases where criminal defence lawyers end up as human rights advocates are those which involve the so-called unpopular causes. In other words, cases which require a lawyer to defend a person who is sometimes publicly loathed or reviled by the community. Terrorism cases represent the unpopular causes of recent times. Perhaps the most famous defence lawyer in Australia in this regard is this is not in the script, but I'm going to say it anyway, the big-eared Marine Corps Major who defended David Hicks, Major Dan Morey. Here was a classic example of a man who was part of the military establishment in a real and practical sense, but as a lawyer saw an injustice he simply could not ignore. And the more he got into it, the more clearly defined was the injustice that symbolised Guantanamo Bay and the military commission process. Major Morey's defence of David Hicks is now a matter of public record, but there are two particular things about him that are important. First, he saw the value of taking up the cause of David Hicks in the media. He was a lawyer who was prepared to confront the vilification and the considered disregard of Hicks's position by an Australian government who at the time thought it was politically beneficial to do so. Morey turned the Australian attitude almost on his own, not so much to David Hicks, but he made people understand the injustice and the breach of basic human rights that was the regime in Guantanamo. The second important thing about Major Morey was that he was supported to the hilt by the officer in charge of the defence section within the Office of Military Commissions, Colonel Dwight Sullivan. He was more unsung, less well known, but crucial to the public contest that Major Morey had engaged in, particularly in the media in Australia, because Morey needed that support for the conduct of the public debate, and he had it without question. I simply cannot leave this topic without making some comment about the remarks of President-elect Obama declaring his intention to close Guantanamo with a particular view of endeavouring to restore the reputation of the United States. I must say the recent election in itself has, to a significant extent, had that effect. I am, of course, very pleased to hear that that's his intention. And this has occurred in part because lawyers who insisted on being involved on behalf of Guantanamo detainees, who were reviled and criticised heavily in the media, the popular media, had made a case. The first step in the making of that case was in the US Supreme Court in the case of Rasool and Bush, which effectively gave the courts a foothold in deciding how enforceable the rights of detainees were. And then later in what I think is a landmark case for the US Supreme Court, not that I'm a particular student of it, but the case of Hamden and Rumsfeld in June 2006. In that later case, I had the pleasure of listening to the recorded oral argument of Professor Neil Katyal from the Georgetown Law School, who argued Hamden and Rumsfeld for the petitioner. His submissions were simply outstanding. It changed almost single-handedly the attitude of the court, and in many respects his ability to make the case and to make the argument and to elevate the status and importance of human rights in the American consciousness was absolutely crucial to the process, and it made people understand the harm that was being done within the United States by the regime at Guantanamo. The Australian government was, I think, the only Western power and ally of the United States to support the regime in Guantanamo. However, the truth is that the regime was an affront to important basic concepts, and apart from allegations of torture and delay in dealing with prisoners, and I say that quickly but not to trivialise their importance, it was an affront to the most basic concept of the independence of the judiciary. The lawyers who acted for the detainees made the argument, put the case, and now finally they have won.